3 words. That is all it takes for a routine Tuesday night drive home to become the worst night of your life. Not a crash. Not a fight. Not even a speeding ticket. Just 3 words from an officer leaning into your window. "I smell marijuana." And just like that, the clock starts. What comes out of your mouth in the next 30 seconds will either walk you home tonight or hand that officer everything he needs to search your car, detain you for hours, and put you in handcuffs. I have reviewed over 300 traffic stop cases built on exactly this moment. Court records, body cam footage, suppression hearing transcripts. And the same 5 mistakes destroy ordinary people every single time. Today I am breaking all 5 of them down, giving you the exact words to say, the exact words to never say, and the constitutional framework that backs every single move, grounded in 4th and 5th Amendment law, Supreme Court precedent, and the real tactical playbook that officers are trained on. 5 mistakes, 5 solutions. By the end of this, those 4 words will never shake you again. Before we get into it, if you are new here, subscribe right now, because every week I break down the constitutional protections most people never learn until it is too late. Hit the bell too. The next video could be the one that changes everything. The officer leans in, says, "I smell marijuana," and then goes completely silent. And that silence gets so heavy, so fast, that most people feel compelled to fill it. They say things like, "I know it smells like that, but I don't have anything on me." Or, "My friend was smoking in here earlier. It's not mine." Or the version that destroys people most often, "Yeah, I smoked earlier, but there's nothing left in the car." People say these things because they genuinely believe explaining the smell away will make the officer move on. That is the trap. The second you confirm the smell is marijuana, even past tense, even someone else's, you have handed the officer verbal probable cause to search your vehicle without a warrant. Your words on that body cam become an admissible statement. "It was my friend's," does not protect you. It may implicate both of you at the same time. Officers are trained on silence as a tactic. Body cam footage shows this pattern constantly. Officer states the smell, goes quiet, and within 10 seconds the driver volunteers everything. That pause is not awkwardness. It is a deliberate technique designed to pressure you into talking. The correct move is calm, polite, and firm. When the officer says, "I smell marijuana," you respond with this, "Officer, I invoke my right to remain silent." Not aggressively, calmly. If he pushes, "Come on, just talk to me," you repeat it, "Officer, I invoke my right to remain silent." A third time if needed. Under Salinas versus Texas, the Supreme Court ruled that simply going silent is not enough. You must explicitly invoke your 5th Amendment right out loud. Once you do that, that invocation creates a legal wall the officer cannot push through. Your silence after that statement cannot be used as evidence of guilt. Do not fill the silence. Fill it with your rights. The driver correctly invokes the 5th after the smell claim. The officer gives it 10 seconds. Then says, "I'm going to need you to step out. I'm searching the car." The driver opens the door and gets out. No verbal objection. No refusal. Just quiet compliance. And that silent compliance is treated by courts as consent to the search. Here is why people make this mistake. They already invoke their rights verbally and assume it covers everything. It does not. The 5th Amendment shuts down verbal questioning. The 4th Amendment operates independently. Without explicitly invoking it, you can still lose your vehicle to a search even after going silent. Courts have ruled that consent to a search can be expressed through conduct, not just words. If you step out and stand aside while the officer approaches your door, that physical cooperation creates an argument for implied consent. Officers know this distinction. A driver who invoked the fifth but said nothing about the fourth is still wide open. The correct move the moment the officer announces a search is immediate and verbal. "Officer, I do not consent to any searches." Say it clearly. If the officer says he is searching anyway, you do not physically resist, ever, but you keep repeating it. "Officer, I do not consent to any searches." Every refusal is captured on that body cam. Every refusal strips the officer of the ability to claim you gave consent later. Then immediately add, "Am I free to leave?" That question forces the officer to articulate independent probable cause to hold you or let you go. These two phrases together form your complete Fourth Amendment defense. Your protection must be spoken, not assumed. The officer claims he smells marijuana. The driver correctly invokes the fifth and refuses consent. Then the officer leans slightly toward the back seat and says casually, "Hey, you guys been smoking tonight?" And the passenger, wanting to help, wanting to end the stop faster, says, "No, officer, we haven't smoked anything in like 3 days." Done. Over. That passenger just handed the officer probable cause he did not have 30 seconds earlier. That answer confirms marijuana was smoked in the vehicle, places all occupants in contact with the substance, and gives the officer an argument that the burnt odor is consistent with recent use. One sentence from a well-meaning passenger just unlocked a warrantless search of the entire vehicle. Under United States v. D. Re, probable cause to search a vehicle does not automatically transfer to every passenger. Passengers require separate, independent probable cause. If everyone stays silent, the officer faces a much harder legal road to justify searching or detaining any individual in that car. The correct move for every single occupant in that vehicle is identical. When questions are directed at passengers, every person responds the same way. "Officer, I invoke my right to remain silent." Not, "We didn't smoke." Not, "I don't know anything about it." When every occupant invokes simultaneously, the officer has no verbal evidence from anyone. Combined with the driver's refusal to consent, the entire encounter becomes constitutionally fortified. Every person in the vehicle invokes. Nobody fills the silence. This is where people who did everything right still get defeated. You invoked your right to silence. You refused consent. Your passengers did the same. The officer walks back to his cruiser. 5 minutes pass. 10. 15. A second patrol car rolls up. Then the officer returns and says, "We've got a K9 unit on the way. Once they do a pass around the car, you can decide whether you want to cooperate." And most drivers sit and wait. They think they have no choice. They think waiting for the dog is just part of the process. That is the mistake. In Rodriguez v. United States, the Supreme Court ruled that officers cannot extend a traffic stop beyond the time needed to complete its original purpose unless they have separate, independent reasonable suspicion of a crime. The smell claim is the disputed probable cause argument. It does not justify holding you for 40 additional minutes while a K9 unit drives across town. Every minute you sit silently after the original stop is complete is a minute you are not asserting your rights. Every few minutes, calmly ask, "Officer, am I free to leave, or am I being detained?" That question forces the officer to make a legal declaration. Either you are free to go, or you are being detained, which requires articulable reasonable suspicion beyond just the smell. Every time you ask, it starts the constitutional clock on camera. If the officer states you are being detained, you respond, "I do not consent to any searches, and I want an attorney." That combination ends further questioning. If the dog arrives and alerts, you continue to state your non-consent. A dog alert may give probable cause for the search, but your verbal refusal is still critical for any suppression argument later in court. Rodriguez gave you the constitutional clock. Use it. You refused consent. You asked to leave. The officer detained you anyway. Now you are standing outside your vehicle while the officer searches it, and his partner stands nearby making casual conversation. So where are you guys coming from tonight? This your car or someone else's? You do this drive often? And because you have been standing outside for 20 minutes under stress, you start answering. Just casual stuff. You think the hard part is already over. Every word is captured on that body cam. Every answer is logged in a report within the hour. And the brutal legal truth is this: police can legally lie to you. They can say the dog already alerted. They can say your passenger gave a statement. They can imply that cooperation will help you. None of those statements are required to be true. And anything you say in response, where you've been, who you were with, becomes part of the evidentiary record against you. Prosecutors do not need physical evidence alone. They need statements and admissions. A search that turns up nothing but a driver who said, "We were at a party earlier," just gave a prosecutor a narrative they can work with at trial. The correct move during and after the search is identical to before it. Every question gets the same response. "Officer, I invoke my right to remain silent." Even after the search ends. Even after the officer says, "All right, you're free to go." And if anything was found during the search, the only words that leave your mouth are these four: "I want an attorney." That ends all interrogation immediately under the Sixth Amendment. Everything after that goes through your lawyer. 3 phrases, repeated calmly throughout the entire encounter, build a constitutional wall from the first question to the last. Here is what changes everything depending on where you live. In Maryland, courts ruled odor alone is insufficient to search a person in 2020 and extended that to vehicles by 2023. In Colorado, after legalization, courts ruled K9 marijuana alerts could not support probable cause without additional evidence. In Ohio, since 2023, smell alone no longer establishes probable cause. But in Florida and Texas, pay close attention. Both states still criminalize possession in significant ways, and courts in both allow odor as probable cause. In Texas, even a small usable amount is a misdemeanor arrest. Know your state. And one argument gaining traction almost everywhere: hemp is legal. Hemp and marijuana are chemically identical in smell. No officer's nose can tell the difference. That argument has succeeded in suppression hearings across the country. Regardless of your state, always refuse consent to search. Your refusal does not prove guilt. Your refusal is your constitutional right. Before any of this applies, run this physical protocol the moment those lights appear behind you. Pull over safely using your turn signal. Turn on your dome light if it is dark. Turn off your engine. Place both hands visibly on the steering wheel. Lock your doors. Roll your window down 2 to 4 inches only. When the officer asks for documents, say calmly, "I am going to reach for my documents," and pass them through the window gap. This protocol controls what the officer can see, smell, and access before the encounter even begins. A cracked window limits plain view claims. Locked doors mean the officer cannot simply pull your door open. The body cam captures a cooperative, deliberate driver, not someone acting nervous. Stay calm. Stay polite. Stay firm. Cooperation does not mean conversation. Respectful does not mean talkative. Your tone matters as much as your words. 4 phrases. Memorize them before you close this video. Am I free to leave? Use it the moment the original stop purpose is complete. Ask it every few minutes to keep the constitutional clock running on camera. I invoke my right to remain silent. Use it every time a question is asked, before the search, during it, and after it. Every passenger uses it too. Under Salinas versus Texas, you must say it out loud. Silence alone is not enough. I want an attorney. Use it the instant anything is found or you are told you are under arrest. This ends all interrogation immediately under the Sixth Amendment. After you say it, say nothing else. I do not consent to any searches. Use it the moment any search is mentioned. Clearly, calmly, repeatedly, on camera. This is your Fourth Amendment invocation. It must be spoken. Print these. Say them out loud right now. Practice them until they are automatic. This is educational content only and not legal advice. Always consult a qualified attorney in your state for your specific situation. If this gave you something, share it with someone who drives. Subscribe to this channel right now, because every single week I break down the rights most people never know they have until they are already standing outside their car, watching it get searched. The next video is already on your screen. Knowing the difference between a smell claim and a confirmed alert could be the one thing that keeps a case out of court entirely. Hit subscribe so you never miss it. Stay calm. Stay silent. Stay protected. This is educational content only. For specific legal advice regarding your situation, consult a qualified attorney licensed in your state.